Hi, good afternoon, everyone. How's everyone's doing?
Great.
This is Simon Westfall-Kwong from the Simon Westfall-Kwong Real Estate Group of Keller Williams. Today, we are going to have Anthony and Gaeta to talk to us about estate planning during COVID-19. If we have time, we're going to talk about some other topic as well. We are going to start, and hopefully more people will join in as well. And Anthony has been an attorney, and he's a licensed attorney in New Jersey and New York, and has been practicing. And this is his specialty. One of the specialties is estate planning. Anthony, I'm going to let you take it off the floor, and please hold all the questions at the end, and he'll be happy to answer all of them for you.
Good afternoon, everybody. Hope you're enjoying lunch and hope everybody's staying safe. I know these are difficult times, and who knew we would have been meeting by a video conference, but here we are. So Simon invited me to talk to you a little bit about estate planning in the context of real estate, and specifically real estate closings. And what I do, what I specialize in is both estate planning, estate administration, that's in the transactional end, and then estate litigation, which usually results when things go wrong. So estate litigation can also accompany poor planning. And planning, really, a lot of people think, well, I just bought my first home, and now we should really think about doing our estate planning at that point in time. Estate planning really shouldn't begin after somebody's bought a home. It should begin before they buy it. And that starts with a simple question, which is, once somebody has agreed to sign a contract and sale is closing and you're out of attorney review, the question should be, how do you want your property titled? And this applies to all of you individually as well, who may be buying and selling property. So for your individual home buyer, usually two people are married, and oftentimes real estate attorneys who don't specialize in planning will draft a deed that will leave the property to husband and wife. It'll say on the deed, John and Sally, tenants by the entirety, or joint tenants with rights of survivorship. Those words have legal meaning. And what that means is, no matter what John or Sally may put in their will, when the death of the first to die spouse occurs, their interest in the property is going to automatically transfer to the other spouse. And that may not necessarily be something that is advantageous for them to do, but they'll have no choice with a deed drafted that way. If I often advise clients that to draft their deed when they're first buying a home, as to draft it as tenants in common. What that means is that each spouse will have their own interest in the house, and it will devolve by way of probate, i.e. by way of their will. So why is that important? A few years ago, New Jersey had an estate tax, and it was very onerous. It was $675,000 and above was taxed. So the planning that the clients received was that they were always counseled to put the house as joint tenants, and when the first to die spouse died, their interest in the house, that half interest, would often go into a trust for the benefit of the spouse that is then living. And that gave us a very good vehicle to shield assets from the application of estate tax. So that's really where estate planning begins, is the drafting of a deed. And the common way that's usually done, which is to place it as joint tenants or tenants by the entirety, is typically disfavored when it comes to that's issue one. Issue two is when the closing occurs, let's say they wanted to put off their planning. One part of estate planning that encompasses not only a last will and testament, but you need documents such as a power of attorney and a health proxy that accompany the will. So when I do estate planning, the basic suite of documents are those three. It's not only a will, it's a power of attorney and health directive. The power of attorney is particularly important because, God forbid, one of the spouses becomes incapacitated. Without a power of attorney, you'd have to seek a court order through a guardianship proceeding, which is very expensive, which involved, I mean, in my experience, they've been at a low of $10,000. In order to get an order to allow the spouse to transact business on behalf of the other spouse. And this becomes very difficult. In the absence of a power of attorney, sometimes one spouse will control all the assets, will have bank accounts in, let's say, his name only, and if he becomes incapacitated, his spouse can't access his bank accounts, can't do anything until there's a guardianship proceeding, which, especially in the age of COVID, is taking a whole lot longer than normal. So a simple document of a power of attorney prepared in conjunction with his estate plan basically ensures and protects against that eventuality and avoids a very costly guardianship proceeding. And this is especially acute, you know, in the age of COVID, where people could be incapacitated and on a ventilator or in a hospital for weeks and months at a time. So those are the planning documents that go into it. It's important to have a POA, not just in terms of accessing bank accounts, but for sales of real property, for effectuating refinances of real property. And these are all things that would benefit your business and make your ability to transact real estate a lot easier. With respect to the transfer of property in an estate, as many of you are familiar with, you need to have, if someone dies, you need to have a tax waiver from the state of New Jersey, basically clearing title. Without the tax waiver, you really can't transfer good title. You can still do transactions and do sales subject to your receipts of the tax waiver. And typically, title companies will want to hold amounts in escrow, but it's just a messier transaction. So if you're dealing with an estate sale of a property, these are questions that you want to ask, and also you want to educate your clients by asking them, how is the property titled? Tenants in common versus joint tenants. Are there liens against the property? Are there debts owed by the estate? And then finally, in what phase is the estate administration? Do you have a tax waiver? A New Jersey tax waiver is a form issued by the state basically saying that the estate no longer owes taxes, and it's recorded as part of a transfer. So how are we doing these documents? How are we signing documents in the age of COVID? Well, the New Jersey legislature, and perhaps many of you are familiar with this, instituted a remote notary law, which allows us via Zoom, if we follow certain steps, we can notarize documents. The problem is a will requires witnesses, and there is no requirement for remote witnesses for wills. There's no allowance for it. Seemingly, it would mean that the witnesses have to be physically present with the testator, meaning the person drafting the will, in order to execute that document. So the last place you want to be is have a client or have a contact who's in a nursing home or in a hospital, and now they have to do their estate plan in a COVID-rich environment by way of remote notarization. Now, I took a continuing legal education course on the new remote notary laws, and this was taught by a Supreme Court approved panel of lawyers discussing the legal implications of the remote notary law. Their advice, notwithstanding going through all of the aspects of the law, was that if you signed a testamentary document by way of remote notarization, they recommended that when you have the opportunity to re-execute the document in the presence of a live notary, that you do so. So that was kind of, telling, and at the same time a little scary, that there's some concern among panelists, even regarding the remote notary law, regarding issues of credibility relating to the execution of documents. So these are the issues with which I deal. Estate litigation in the context of estate planning. So sometimes you have issues relating to title that need to be cleared up by way of a court action. And I brought those actions to quiet title. I understand the aspects of when a lien is valid and how to deal with it. Could be by escrowing money and a simple fix like that. Others require more detail. But there are legal ways in working in conjunction with an attorney and a litigation process to propel a sale forward. So if you feel you're running into, or your seller or buyer are running into legal issues relating that need litigation to cure, my firm is able to craft these solutions in the context of a case that has to be litigated that would allow a sale to occur, or better yet, I could seek an interim order from the court allowing the sale to proceed, which would get you and your clients where they need to go, and then I deal with the aftermath with respect to that. Now, digging into estates and estate litigation, real estate, I just had a case, and I'm seeing more of it with COVID, and I was seeing a lot of it just by virtue of the baby boom population starting to starting to reach the age where they're dying off. And generally speaking, I'm seeing trends where you have a older population with significant amounts of wealth. You have a younger generation that isn't making the money they thought they would, and sees mom and dad's wealth as the last chance for them to actually get a financial foothold for the rest of their lives. And people are acting in a way that is really disgusting. I've seen cases where a brother cuts out his two siblings from an estate. I've seen money stolen from older relatives, from mothers-in-law. So these are the estate litigation cases that I deal with. One case in particular I just settled. It involved a $1.2 million estate. Well, we had a son basically had his 101-year-old mother sign a will transferring the overwhelming majority of the estate to him, to the exclusion of his brother and sister. And what did he do? He effectuated a deed that transferred a shore property to himself. Now, why is that, besides that being undue influence in the law, why is that bad? As some of you may know, when someone dies, the assets that they have at the time of death are stepped up in basis. I can't see any people raising their hands, so I'm just going to explain what that means. A step up in basis relates to the purchase of an asset. So by way of example, if you bought IBM stock at $100 a share, you used the money that you worked hard for and pay taxes on to buy that share. So that $100 is not going to be taxed again. The $100 is invested in IBM. Let's say IBM goes up to $150 a share. Well, if you were to sell it while you're alive, you're obviously going to pay tax on the difference between what you bought it at, $100, and what you sold it at, $150. And so the $50 capital gains is subject to tax. What the government says, and similar to real estate, you buy a house for $25,000, goes up to $100,000, and you sell it, you're paying tax on $75,000. Government says if you bought that house at $25,000 and you die with the house be worth $100,000, your heirs get your new basis. It's called a step up in basis. It's a huge, huge, huge giveaway. And the theory behind it is that at the moment of death, there is in place a tax system with a certain limit of an exclusion on tax. So your estate, when you die, is technically exposed to tax, but no tax is imposed on it. By virtue of that tax exposure at date of death, the government treats your assets as stepped up to the value in which as of the date of death. So this is tremendous for people thinking about selling real estate. An older person who has an asset and absent other considerations may want to hold on to it. So maybe a refinance, if they need equity, is the right solution for them. And then upon their death, then they're going to sell the home to a third party. In that particular case, from your point of view, you could assist with both a refinance transaction and an ultimate sale of the asset, as opposed to a person selling the house for $100,000, paying capital gains on the $75,000 difference and having that much less left over for their heirs. Conversely, let's say I bought that same IBM stock for $100 and it fell to $25 a share. Well, the heirs would get the new basis as well, meaning the loss. You would lose the ability to capture that loss. So if you have a client who's older and has a house or a piece of real estate in which they suffered a loss, the proper advice and the proper planning advice they'd get from this office would be to sell that asset and in order to capture the capital loss and then propel it forward or depreciate it or apply it against any other gains you possibly can. So these are some of the strategies and the considerations that we deal with with respect to real estate. Perhaps the most important part of proper planning, and given that New Jersey presently doesn't have an estate tax, and given that the federal exemption is, I think, $15,500,000 now, the most important consideration for planning are your kids. If you die without planning, so let's say you're a single parent or if you're divorced, and you die with assets and without a will, but with minor children, guess what happens to your assets? You have to go to surrogates court. The surrogates court are going to appoint attorneys to make decisions regarding your assets. The assets will then be deposited in court, and I guarantee you they will get minimal gains on those assets. Your children will receive that money at age 18. Now, if you can imagine an 18-year-old with several $100,000 in assets, I know at 18 I wasn't exactly thinking prudently and about my future where I would inherit that type of money. I'd probably be in Cancun somewhere. But that's about the last thing any parent wants. So as part of the planning process is you create, and what I do is I create testamentary trusts. Now, what are testamentary trusts? Testamentary means in the will. So the trust doesn't become active until date of death. So for all you know, you may live a very long life and never use it, and it exists in your will, and then your children reach the age of majority, or whatever age in your will you think they should get assets, and then that provision would never be triggered or would be triggered up to a certain age. So the benefit is by planning now and having minor children, you avoid the nightmare scenario of your assets being, in essence, taxed and charged by attorneys who are making decisions with respect to your and your children's money, an ultra-conservative court that's going to, preserve principle at the expense of gains, and your kids are going to get it at 18. The typical planning advice coming out of the trust that we create, usually parents don't want their children, they want the money available for college, and you can certainly draft provisions. It's called health support and maintenance, or actually health maintenance and support. It's called HEMS, HMS, health maintenance and support. And that's a commonly understood legal phrase that would give a trustee of your choosing the right to apply that money for your children's benefit, their education, housing, necessities. And then the money itself would not be released to the child in full until a time when you decide. As some of you may be thinking, this also helps protect the child from marital issues, marital difficulties. Because if they inherit the assets, while inherited assets typically are not treated as part of equitable distribution, sometimes people make the mistake of commingling their assets with that of their spouse. As soon as they commingle them, meaning if Johnny inherited assets of $50,000 and he and Sally get married, and then he and Sally have a joint account and he puts $50,000 into that account, if they get divorced, Sally has a legal claim for that $25,000. If Johnny would have kept the account separate and maintained records showing how he can trace the money back to the inheritance, then that money is his for purposes of equitable distribution. She can't get at it. But notwithstanding that, she would still be entitled to the part of the income being thrown off of that. Why? Because it goes to the issue of spousal support and the income he's making. you may have inherited an asset, but the money that you receive from that asset is yours. And it's analyzed in the context of a spousal support settlement. If that asset is locked into trust, that means that, and the trust is drafted in a way that gives the trustee discretion over distributions from the trust, sole discretion, such that there's no mandatory distributions to the beneficiary, that's Johnny in this case, and that the trustee is sole and absolute discretion, that asset and its income will not be touched, would not be looked upon for purposes of marital and equitable distribution. So one caveat when it comes to trust planning, and this kind of ties into where I began with my presentation. Caveat to trust planning is that trust income is taxed at what we call a compressed rate, meaning that you reach individually, if you look at the individual income tax, you reach the top rate, somewhere above $450,000, the top income tax rate. The trust top rate is reached after $12,000 in income. Now, why do you get such a large income tax rate on a trust? Well, the government says, because you're putting the asset in trust, you're deriving certain benefits from that trust structure. And in return for that, you got to pay higher income tax. So that's why I love real estate and putting real estate into trusts. That's why I tell people to draft their deeds as tenants in common, because it gives you the flexibility at the planning level. When you do your will, you can give your fiduciary the option to take your half of the house and put it into a trust for the surviving spouse's benefit. That asset will then grow tax-free in the trust. And if it's your primary residence, guess what? It's not throwing off income. If anything, assuming it's not a two-family house or whatever, but a single-family home, not throwing off income, it's creating losses and depreciation. And well, I mean, I know the tax code has since changed, but depending on how you structure the ownership and what you can justify tax-wise, you can take advantage of the losses, or at least the lack of income that is coming off of the residence. And therefore you take advantage of shielding and sheltering value without the application of a compressed tax rate in a trust structure. So I've covered a lot. I hope I broke it down in a way that everybody can follow, and I'm sure there'll be questions. I know I had questions when I was learning this stuff, but as you know, I hope you all took away a lot of important information and concepts from this. And I think you can see, obviously, the implications for how you guys are selling real estate and how valuable some of this could be. So with that, I'll open it up to questions.
Anthony, how soon someone should plan estate planning? That should be their first home they purchase, or they have multiple properties? What would be the right step? Right from the beginning, they should already have that in mind, because I think I would think most first-time home buyer wouldn't have that in their mind to plan this in advance. Yes,
absolutely. You should, if you have the assets to purchase a house, then you should talk about planning. And what I was suggesting from the beginning is that one easy segue to talk about planning would be to say, well, how do you want your property titled? And people will say, well, in my name, right? Well, yeah, but is it going to be owned by an LLC, or are you going to own it individually? Are you going to, are you married? Do you want it as tenants in common, or do you want it together with your wife? And just to touch on two other concepts regarding titling and regarding asset planning. If any of you, or if the buyer has a special needs child, very, very, very important. I can create, and the law allows us to create, special needs trusts. If you die without a will and you have a special needs child, and that child is your direct lineal descendant of your estate, the money's basically going to go to Medicare, go to the government to reimburse them for the benefits that are paid to your child, number one. So you have to, if you have a special needs child who's a direct lineal descendant, you have to have a planning conversation. You're doing them and yourself a disservice. The way special needs trusts work in a nutshell is that your assets, your child would get the benefits they're getting. The money goes into a trust for their benefit. The trustee has sole and absolute discretion to use that money in a way to benefit that child, but not in a way that would adversely implicate the benefits that they're receiving. won't adversely affect them. So that is the planning you have to do if you have a special needs child, somebody on benefits. Issue 2 that just came in my office with respect to titling. There was a case involving a lot in Bayonne. Person bought it, husband and wife, he bought a lot with a house on it and a vacant lot next door, titled it together. And I knew as soon as he said it, what he was going to say. So he paid full value for 2 buildable lots. One was developed, one was being used for parking. The town of Bayonne, city of Bayonne, basically the tax assessor said, these 2 are titled together. I'm going to treat everything as one lot, and just did it. If it was titled, if adjoining lots and undeveloped lots are titled differently, i.e. LLC 1, LLC 2, LLC 3, or if he just would have put one property in his name, one in his wife's name, the tax assessor could not have done it, and you would have preserved the integrity of the zoning structure. When you have a revisiting of the master plan by a town and redevelopment, these are things that occur unbeknownst to ownership, and this is the advice that clients need to receive if they're buying adjoining lots, adjacent lots, and servient estates that are serving developed properties. So that's a long answer to a short question. You have any more questions?
Anthony, thank you for this information. Really appreciate it. How do you envision that we buy property with friends and family in an LLC? When there are multiple, we have a certain property that we have in LLC and we are buying more. So how do you envision we structure that in such a way that the liability is also limited to the percentage of holding within the LLC, especially because it's a new LLC and they do not have assets, so it has to be backed by the personal guarantee of the LLC member.
Well, it sounds that would be obviously a conversation that we'd have to have in the office regarding all the moving parts. And I can't give legal advice, without a full picture. I can speak generally as a general proposition. For every piece of real estate you buy, generally speaking, you want an LLC type structure, a liability limiting entity owning it. If you own a business and the business operates within property that you buy, you can never, ever, ever, ever have the business owning the property, because it creates an asset that's attachable for liability purposes. Always, 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 at least the advice I always give, is if you're going to buy the property, that's one LLC, your business is another LLC, and then there's a lease between both LLCs, business. Okay. But as far as to your question, I'd be happy to sit down and talk with you. Sounds like there are a lot of moving parts. You did say something that caught my ear about how to limit the liability of an owner of units within an LLC. Well, you can't limit it at the individual ownership level of an LLC. There are other vehicles you can do for that, but the LLC itself should serve to limit liability to the owners of the unit holders of the LLC by virtue of its nature. The LLC is by definition a limited liability company, and the structure is that the liability is limited only to the assets of the LLC itself. It doesn't extend to the owners.
Thank you.
Sure. Any other questions? Okay.
So Anthony, I know that you also specialize in other categories as well. You want to tell us a little bit more what else you also cover in your law firm?
Sure. Just very briefly, as you heard, I touched upon some aspects of divorce. I mean, all the areas in my firm, and you can check out my website at www.gaetalawfirm.com. And I'm sure Simon will post it, toward the end, and I'll send a set of business cards, to him, so that you have that. But all my practice areas were specialized in, and they happen to all relate to each other. So you heard me talk about estate planning and real estate as it might affect a matrimonial or divorce scenario. So I clerked for a matrimonial judge for a year. I do family law, although it's a limited practice. I typically limit it to high net worth clients, and it's not at the forefront of what we do. But what I do is very good, and I deal with, obviously you can imagine if you're a high net worth client, I'm dealing with aspects of planning and estate stuff as well. So that's why the expertise is brought to bear in that realm. I do land use and zoning. My partner who I share office space with his name is Tom Brunage. He is a land use attorney of 50 years. He operates in the Meadowlands. He has a stellar reputation, an absolutely excellent record. He's been before all courts, Supreme Court, Appellate Division. Really knows his stuff, and he does things right, and he'll tell you square at the table whether you can do a thing or not. So that is a big aspect of this firm as well. So if you have developers who are looking to generate a site plan, and I know I've dealt with applications where sales were subject to site plan approval, that is something we can handle, certainly. We also do commercial litigation. We litigate over contracts, leases. We also deal with landlord-tenant matters. I know in the age of COVID, they're basically not enforcing evictions at this point in time. But one has to think that given the unemployment numbers and given the amount of backlog, it's going to crest at some point when when we're out of COVID, whenever that may be.
Great. Thank you so much, Anthony. Your information, your website is actually inside the chat, and also your phone number is there as well. Talk to us about typically, how does your fee structure work?
Sure. Typically, my standard hourly rate in New York and New Jersey is $500 an hour. I discount it down to $400 an hour for anybody referred to me from a referral source. So anyone doing business with me would come in obviously through Simon or any of your agents, Simon, and that would be reflected in my retainer. And so I would reference the referral in my retainer agreement so that people are reading that not only are you someone who is handling their real estate transaction, you're someone responsible for a discount on a legal bill of $100 an hour. So I make reference to the relationship, and clients seem to like that and understand what that is. So that's typically how I work on an hourly basis. There are times where I'll do a contingency. That's rare. There are times when I'll do a hybrid retainer, where if the client can't afford the $400 hourly rate up front, we will do a lower discounted hourly rate in return for a percentage of the ultimate outcome. So those are the structures of fees, but mainly I am hourly billing.
Great, excellent. Anyone else have any question? It sounds like we should do a separate lunch and learn for tenants and landlords, because that's a hot topics as well during COVID. So I'll get in touch with you another time, and we can set up a time to discuss that part, to cover that, because there's a lot of stuff going on that as well. Thank you so much for your time, and definitely, Anthony, if you want to actually type in your email address in the chat box, and so people can actually email you directly, and that would be great. And obviously, you can also call him. The phone number, his law firm phone number is on there, and so you can touch base with him. And if anyone has any questions, definitely can get in touch with Anthony directly. Thank you for joining us today. This is Simon from the Simon Westfall-Kwong Real Estate Group of Keller Williams. We always listen to real estate need and bring you results. So if you guys have any other topics you want to talk about, please email us at simon@swkrealestate.com, or get in touch with us at 973-489-8885, 973-489-8885. Have a great day today, everybody. Enjoy the rest of your Friday, and have a great weekend. See you later.
Thank you, Simon. Take care.
Thank you.
Best, everybody. Bye-bye.